What's up, everybody? It's Peter Tragos, the lawyer you know, and today we're back in the Petito Laundrie saga, breaking down the Laundrie parents' motion to dismiss filed by Tampa lawyers that we know very well at Trombley and Haynes. The managing partners there came up with my dad, worked on a ton of cases together, and Matt Luca, one of the younger lawyers there, we've known, good lawyer. It's a really good motion to dismiss. We're going to talk about it. There are some things I would have done differently, maybe some parts I would have left out, some different strategy that we'll talk about. But at the end of the day, we'll see whether or not we think, after breaking down this entire document, we think this complaint is going to get dismissed, and whether or not they're going to have another chance as the plaintiffs to amend and refile this complaint. So if you guys enjoy this kind of video where we break down the actual documents, court documents, talk about them, explain them, hit the like button and subscribe to our page so we know that. We know this is the content you're interested in. We'll try to get through them as quickly as we can. As always, I don't want to bore anybody, but I want to hit all the important facts in this motion and talk about this case because it's content that you guys seem to enjoy. So let me know in the comments as well as we go through this document, whenever you feel like you've made up your mind. If you think this case should be dismissed, then write dismissed in the comments. If you think that it should not be dismissed, write not dismissed in the comments, because I want to know whereabouts you think you have made up your mind, and you can let me know by using the minute mark, by what part of the document in, or whatever it may be. So let's jump into that document now. All right, so we have the defendant's motion to dismiss here, the Laundrie parents, and the reason is for failing to state a cause of action for intentional infliction of emotional distress. But there are other reasons that he gives throughout this entire document that we're going to break down. Generally speaking, if you remember back when we broke down the complaint, we talked a lot about how it didn't actually say what the cause of action was, didn't actually say intentional infliction of emotional distress. We kind of guessed it could be this, it could be negligent infliction of emotional distress. We talked about how it could be a couple of other things, but they really didn't specifically state a cause of action, which is one of the things they're going to harp on here. The background, we're just going to skip through because we all know at this point the background of Brian and Gabby going on the trip. Gabby comes up missing. Brian comes back home. What he told his parents, we're not sure of, but later he admits to killing Gabby Petito. Her body is found sometime later. And this complaint for, I guess, intentional infliction of emotional distress was based on the fact that Brian Laundrie's parents didn't do anything to help with finding her body. They delayed her parents and added to her parents' emotional distress, not knowing whether she was dead or alive and where her body was or what happened to her. That's generally the background. But now let's get to the law, because there are a lot of interesting aspects to what was wrong with this complaint and why the defense thinks it should be dismissed. The complaint should be dismissed with prejudice. Again, if you remember back to the Kyle Rittenhouse trial, we talked a lot about with prejudice and without prejudice. If something is dismissed with prejudice, it cannot be refiled. The case is over. You have won as the defense. If it is dismissed without prejudice, that means that the plaintiff, or in that case, the prosecution, can file it again. So if it was without prejudice in Rittenhouse, they could have come back and tried the case again. Here, it's the same thing. If it's dismissed with prejudice, they cannot refile this complaint as the plaintiffs. If it's dismissed without prejudice, then they have the opportunity to amend the complaint and refile. And I'll just tell you and let the cat out of the bag here, almost always is the first complaint dismissed without prejudice, meaning the plaintiff will get another opportunity to file an amended complaint, yet they are trying for the full swing here to win, asking for it to be dismissed with prejudice. Although leave of court to amend a pleading shall be given freely when justice so requires, they basically know that they're going to get another opportunity to amend it. Although they say leave to amend this complaint need not be given where the amendment would be futile. And they're saying there's no way that they could file a legitimate claim, a legitimate complaint with a legitimate cause of action based on the facts of this case. A proposed amendment is futile if it is insufficiently pled or is insufficient as a matter of law. The complaint is insufficient and deficient as a matter of law for many reasons, and those deficiencies cannot be cured by an amended complaint. So if it's just they misspelled the name or they need to fix something, they can amend the complaint and do that. But if there's no way under any circumstances that you could ever have a viable cause of action that could be pled properly in a complaint, then it can't be cured with an amended complaint, and that's what the defense is arguing here. The gravamen of the claimed wrongdoing is that the Laundries exercised their constitutional rights and essentially made no statements to plaintiffs or law enforcement. As a matter of law, the Laundries' silence or conduct could not form the basis of a claim of intentional infliction of emotional distress. the Laundrie's constitutional rights and the elements necessary for such a cause of action would not change with an amendment of the complaint. Furthermore, the time period at issue occurred several months ago, and the foundation of the plaintiff's claims distressed, wanting to find their daughter, has been resolved. There are no more facts that could emerge that would bolster the plaintiff's claims, meaning all this has already happened, and we already know what's happened, and we already know that they hid behind, or I don't want to say hid behind, they stood behind their constitutional rights. So what's happening now is not going to add, so they can't amend the complaint because there's no new evidence coming out since the time they filed the original complaint. There are no more facts that could emerge that would bolster the plaintiff's claims. The plaintiff's failure to state a cause of action in the complaint provides ample basis to conclude that the plaintiffs would not be able to add the missing but required information if provided with another opportunity to bolster their allegations. As an amendment to the complaint would be futile, the complaint should be dismissed with prejudice. Now, the general pleading deficiencies. The plaintiff's allegations attempt to set forth a cause of action for intentional infliction of emotional distress. As an initial matter, the complaint's ambiguity and lack of separate statements and counts as to each plaintiff and defendant pursuant to Florida Rule of Civil Procedure 1.110 independently warrants dismissal for repleading. Okay, what he means there is the complaint was just very general. It's these two plaintiffs against these two defendants for all these actions with no specific cause of action. And usually in Florida, the way you have to do a complaint is plaintiff number one against defendant number one, plaintiff number two against defendant number two, plaintiff number one against defendant number two, and plaintiff number two against defendant number one. And you have to go one for one, one for one. Now, if there are derivative claims or vicarious liability, sometimes you can combine them. There are some exceptions, but generally speaking, so that each defendant knows what they're being charged with or complained of, they need to know. It needs to be pled with specificity against them. Because I can't say defendant number A and B both did all this stuff to me. I have to say exactly what A did and exactly what B did. There can be some crossover, but I have to let each individual one know, and especially because I may settle with one or I may settle with the other. And if I do that under this complaint, I don't know what I'm settling with defendant A or defendant B, and I don't know if I'm settling against plaintiff one or plaintiff two. So a lot of times you have to split that up so everybody knows exactly what's going on and so that they can properly defend themselves. Now, they argue this is just some publicity stunt, so it doesn't matter who they're suing and they're never going to settle. Well, the courts don't want that. But if you see, it says it independently warrants dismissal for repleading, which means you dismiss it without prejudice. They get to fix it and say exactly what plaintiff one is going against defendant A and plaintiff two against defendant B. They can just refile that complaint. So they're saying, yes, that's what needs to be done, but there's more and we think it needs to be dismissed with prejudice. The defendant's allegations must be sufficient to inform the defendant of the nature of the cause of action against him. The defendants assume the cause of action is one for intentional infliction of emotional distress because the words relevant to the elements of that cause of action appear in the complaint, which is exactly what we talked about. We are not even positive what cause of action they filed this complaint under, and that's a problem. And people ask what I would do differently. I definitely would have set it out differently. Specific cause of action, specific counts. Our complaints always have count one, count two, count three, count four with the cause of action and who the plaintiff and defendant is. And a lot of times it'll say count two as to defendant B or whatever. It's also possible that the plaintiff might be trying to sue or allege a cause of action for tortious interference with a dead body, but it's not at all clear. Florida Rule of Civil Procedure requires that a complaint must state a cause of action. If a complaint is so vague, indefinite, or ambiguous as to wholly fail to state a cause of action, it's subject to dismissal. But again, even if it's dismissed, the plaintiff always gets a second bite at the apple to amend the complaint and bring it back. The tortious interference with the dead body is usually only against funeral homes where they mishandle the dead body, cause emotional distress, remove the head before the open casket, and the family comes and sees the body without the head or something like that, puts the wrong body in the casket or loses a dead body. That's usually what that means. I don't see how it would apply here, honestly. Plaintiff's complaint ambiguously draws language from two unidentified causes of action and does not identify either as the cause of action upon which it relies. That deficiency requires dismissal. The complaint is further deficient because it names two plaintiffs and two defendants without attempting to distinguish between the two. We get that. We already talked about that. Commingling various claims against all defendants together may warrant a dismissal of the complaint. Again, we get that. We went over that. But again, it would usually allow for them to refile. Now, it says, with these two pleading deficiencies require dismissal and could potentially be corrected by amendment. But plaintiff's legal theories are fatally flawed and could never be remedied. Let's get to what those fatal flaws are eventually. The complaint fails to meet factual pleading requirements. Again, this argument is going to be one that can be fixed with an amendment. If they don't plead it specific enough, if there's not enough facts, you can fix that with an amendment. Pleadings must be something more than an ingenuous academic exercise in the conceivable. Florida is a fact pleading jurisdiction. To withstand dismissal, a plaintiff must allege more than a naked legal conclusion. It is insufficient to plead opinions, theories, legal conclusions, or argument. The quality of pleading that is acceptable in federal court and which will routinely survive a motion to dismiss for failure to state a claim upon which relief may be granted will commonly not approach the minimum pleading threshold required in our state courts. So saying we need even more in the state courts than what we usually need in federal court. Florida officially recognized the tort of intentional infliction of emotional distress in Metropolitan Life Insurance Company. It was adopted with Section 46 of the Restatement of Torts. The state of cause of action, a complaint must allege 4 elements: deliberate or reckless infliction of mental suffering, outrageous conduct, the conduct caused the emotional distress, and the distress was severe. Behavior claimed to constitute the intentional infliction of emotional stress must be so outrageous in character and so extreme in degree as to go beyond all possible boundaries of decency. In applying that standard, the subjective response of the person who is the target of the actor's conduct does not control the question of whether the tort or intentional infliction of emotional distress occurred. Rather, the court must evaluate the conduct as objectively as possible to determine whether it is atrocious and utterly intolerable in a civilized community. Even if a complaint alleges facts, those facts, if proved, must establish a cause of action which relief may be granted. While the plaintiff alleges some facts, those facts could never establish a claim for intentional infliction of emotional distress because the Laundrie's actions were legally permissible, constitutionally protected, not outrageous, and do not give rise to any cause of action. Now, this to me is where they start to get into, and these are some of the things I would do differently. This is when they start to get into some things that I may argue as a plaintiff are up for summary judgment and not necessarily appropriate for a motion to dismiss. If I was them, and I realize why they did it this way, but if I was them, I would have just filed a motion to dismiss based on the fact that this pleading is too vague. They need to give us a cause of action, and they put all the plaintiffs and defendants against each other in one thing, and they didn't separate them out. That would be my argument. Pretty sure I would win. Motions to dismiss are supposed to be on the 4 corners of the complaint. I would win. They would have to amend the complaint and refile it. Once they refiled it, then I may file a motion like this, depending on what facts they put in there. But now they're putting all the facts in here and kind of letting them know where they're going. All right. The Laundrie's inaction was not outrageous, but legally permissible and constitutionally protected. This is when they're going to get into the 5th Amendment right to remain silent, which is very real, and what the Laundries could have been doing in this situation to not incriminate themselves. Outrageousness is the threshold for test for recovery in an intentional infliction of emotional distress. And we talked about this. It's very hard to go forward on just an emotional distress claim, and here are some of the reasons why. Whether conduct is outrageous enough to support such a claim is a question of law, not a question of fact. Importantly, the standard for outrageous conduct is particularly high in Florida. It is not enough that the defendant acted with an intent which is tortious or even criminal, or that the defendant intended to inflict emotional distress, or even that the defendant's conduct can be characterized as by malice, or a degree of aggravation which would entitle plaintiff to punitive damages, which we've talked about before. It has to go above and beyond. It has to be incredibly bad to get to punitive damages. Well, that may not be enough in an intentional infliction of emotional distress, because rather liability is established only where the alleged conduct is so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. Generally, the case is one in which the recitation of the facts to an average member of the community would arouse his resentment against the actor and lead him to exclaim, outrageous. Now, we'll get into the constitutional protections, but a lot of people in this case in the community said exactly that toward Laundrie's parents. So I don't know if these lawyers, want to really go there with the public, but they were outraged at how the Laundrie parents acted throughout this situation. Now, that's not the only bar, and just because the public was outraged by it doesn't make it raise that bar. But that legal argument, if I'm the plaintiff's lawyer, I'll say I can pull some news clippings and some YouTube comments that say the public was outraged. The law is clear that a pleading is insufficient if it contains merely conclusions, as opposed to ultimate facts supporting each element of a cause of action. Very true in Florida. When we file our complaints, we have to put in enough facts, but if we don't, we always get another chance to amend the complaint. Although the complaint alleges the Laundrie's conduct was outrageous, the complaint's failure to provide factual support rising to the level of outrageous conduct makes that allegation nothing more than a legal conclusion. The essential allegations against the defendants are nowhere close to meeting the necessary standard. Those allegations are, without providing any factual support, the complaint states it is believed that Brian Laundrie told his parents that he murdered Gabby Petito. Christopher and Roberta Laundrie spoke to and hired an attorney on September 2nd. After September 1st, there was no contact between Laundries and Joseph Petito and Nicole Schmidt. The Laundries went on vacation. They blocked their cell phone numbers. Their attorney made statements. And the Petito parents sent letters to the Laundries' attorneys. And that was basically the allegation of the facts. Let's see what else they said here so we can skip through this a little faster. Although the complaint makes several accusations about Brian Laundrie's conduct, it is not a defendant. He is not a defendant in this case, nor is there any legal theory that would impute his conduct to the parents. And again, that's very important. A lot of the actions surround what Brian Laundrie did. Brian Laundrie is the one that did the wrong, that created the emotional distress, but he is not a defendant in the claim. None of the allegations recited above, either alone or together, describe outrageous conduct. In fact, the complaint fails to allege conduct at all. Basically, the complaint alleges that the Laundries failed to have any contact with the plaintiffs when the plaintiffs wanted to speak to them. That allegation falls so far below the particularly high standard for outrageous conduct that the complaint should never have been filed. The only affirmative statements alleged in the complaint were made by the attorney for the Laundries, which is entirely appropriate under the circumstances. Conduct claimed to cause severe emotional distress must be so outrageous in character, so extreme, okay, beyond all decency, which we know. We understand you're going through a difficult time and your instinct to protect your son is strong. The plaintiffs cannot express sympathy and understanding for the Laundries' unenviable position and then claim the Laundries caused them emotional distress by not responding. So again, having your lawyer speak for you, not speaking when you could be under criminal investigation, not violating your Fifth Amendment right or waiving your Fifth Amendment right are not elements for intentional infliction of emotional distress. Some of this we mentioned in our prior discussion of the complaint and where it fell woefully short at times to actually explain what the cause of action, what the facts are against the Laundrie parents. Labeling the Laundries' silence as outrageous is particularly incongruous with the context of the attempt to contact the Laundries discussed in the complaint. The only attempt at contact alleged is that the attorney for the plaintiffs issued a letter to Christopher and Roberta asking for help and located Ms. Petito. And just so you know, once you know somebody's represented by counsel, you as a lawyer can't reach out to them individually. You have to reach out to their counsel. So there was no way to have any communication with the Laundries anyways once everybody knew they had retained counsel. So once the Petitos retained counsel, the Laundries retained counsel, the only way they could talk was between those lawyers, again, which is they're acting like is some wrongdoing in this intentional infliction of emotional distress. The complaint says nothing about whether the Laundries actually received the letter. Furthermore, the intent element alleged is insufficient. The complaint accuses the Laundries of acting with malice or great indifference of the rights of the plaintiff. However, Florida law is clear that acting with malice or indifference is not enough. Outrageous conduct is required, which is why I said in the initial video, maybe it's negligent infliction of emotional stress because I really don't think it rises to the level of intentional. Well, that's exactly what they're getting to here. Even if the court were to have reservations as to whether the Laundrie silence was outrageous, to permit this claim to move forward would trample on their constitutional rights, and no court nor court of law ever wants to do that. All right, the Laundries are entitled to exercise their legal rights. Refusing to respond to law enforcement, again, this is just the long-winded way to go through again. They have a Fifth Amendment right, and the actor is never liable, for example, where he has done no more than to insist upon his legal rights in a permissible way, even though he is well aware that such insistence is certain to cause emotional distress. Because if you think about it, in every case where you're accused of a crime, if you remain silent, you could be causing emotional distress to the family of the victim. We can't have victims suing defendants over that emotional distress to remain silent, especially if they were never convicted of anything. So you're basically suspecting that something criminal happened. They didn't say anything. They were never charged, never convicted, yet you're going to sue them for emotional distress because they remain silent. We can't have that in the law, and that's exactly what this section kind of goes through. General constitutional right not to speak on any topic, and more specifically, not to speak. So they're saying they also should have a constitutional right to not speak, a First Amendment right, but also obviously the Fifth Amendment right is the big one that the courts don't want to trample on. First, Fifth, and Sixth Amendments is what they're undertaking here. Put simply, the Laundries have fundamental constitutional rights to silence, privacy, and representation by counsel, but the Laundries' exercise of those rights is what the plaintiffs claimed caused their emotional distress. The Laundries' rights are inalienable, and the Laundries can never be liable for exercising their rights in a permissible way. Thus, as a matter of law, the plaintiffs have not alleged any act or conduct on the part of the Laundries that would impose liability upon them, which would survive a constitutional challenge. I agree, but I still think, and in case you haven't picked up on it yet, I think the outcome of this is the complaint is absolutely going to get dismissed, but without prejudice, and the plaintiffs are going to be able to amend the complaint and refile the complaint against the Laundrie parents. At that point, we will have another motion to dismiss, probably to talk about that may have more legitimate reasons for dismissal with prejudice once the plaintiffs have had the opportunity to amend the complaint. All right, here we go. Now we're going to start talking a little bit about the impact rule, which we did a whole video on, and a lot of you had thoughts about. The plaintiff must be present. The complaint suffers from another fatal flaw that is further evidence as to why there is no cause of action for this factual scenario. For conduct to be actionable as an intentional infliction of emotional distress, the conduct must be directed at the plaintiff or in his or her presence, a la the impact rule. We'll skip all the case citings. I mean, we can see some of what these cases stand for. Father and children may not recover when alleged extreme and outrageous conduct was directed only at the spouse/mother. In all cases we have found in Florida, recognizing the tort of intentional infliction of emotional stress, the plaintiff was the recipient of the insult or abuse. We are unable to conclude that learning the awful truth from MPS afforded appellants grounds for recovery for their own distress. And that's what we talked about. Just hearing that something has happened to a family member, as distressing as that is and as miserable as that is not enough for this type of cause of action. As set forth in the complaint, there is no contact between the Laundries and the plaintiffs after September 1st. If there was no contact, then the Laundries certainly could not have committed any act in the presence of the plaintiffs that would support a cause of action for intentional infliction of emotional distress. What happened to Ms. Petito is certainly unfortunate. However, the Third District Court of Appeal reasoned if courts were to allow relatives of tort victims compensation for the distress they suffer when they receive bad news about family members, when there is no attendant intentional or reckless conduct directed toward them, an avalanche of litigation would ensue. Compensation is available for the actual harm to the victim. Only in carefully prescribed circumstances is compensation permitted for relatives who suffer emotional distress. It is not lack of compassion, but necessity that restricts the relief to the immediate victim. Again, it would be impossible for the courts to handle everybody that was touched by a victim's life and give them compensation against the defendant or other defendants, especially the family of the defendants. This would open up the floodgates and be very difficult for the courts to deal with and economically impossible for most people to pay in these situations. Now, let me know in the comments if you think that law should change and the families of victims should be able to sue defendants and people that wrong victims, personally hurt them, kill them, whatever it may be. Now, as a society and public policy, we may disagree with that. We think people should get compensated for that. But practically speaking, at this point, the courts have found that that's an impossibility. Causation and severity. The last two elements necessary to state a claim for intentional infliction of emotional distress require factually supported allegations that a defendant's outrageous conduct caused the victim emotional distress that is severe. So we're talking about whether it caused it and whether or not the emotional distress was severe. The plaintiffs all but concede in the complaint that the Laundries did not cause the plaintiff's grief. The complaint alleges that the Laundries knew of the mental suffering and anguish of the plaintiffs and knew they could alleviate, at least in part, such mental suffering and anguish by disclosing what they knew about the well-being and location of the remains of Gabby Petito. By setting forth that allegation, the plaintiffs acknowledge that their mental suffering and anguish existed prior to and independent of the Laundries' conduct of remaining silent, meaning they were having this emotional distress based on the disappearance of Gabby and then the death of Gabby at the hands of Brian Laundrie, but not at the hands or words of, or lack of hands of the Laundrie parents. Rather than alleging that the Laundries were the sole and proximate cause of the plaintiff's distress, in essence, the plaintiffs allege that the Laundries' silence failed to alleviate it in part. So, I mean, they didn't fix it when they could. And failure to alleviate is not the sole and proximate or legal cause of their alleged injury. Stated differently, the complaint's own allegations contradict the theory that the Laundries caused the plaintiff's mental suffering and anguish. The complaint alleges that the Laundries were the direct and proximate cause of their injury and also alleges that the plaintiff's grief was caused by something other than their silence, meaning, which is it? Is it Brian Laundrie and what he did, or is it the Laundrie parents? Because if it was just the Laundrie parents, you should not have been distressed until they didn't tell you what happened. Both as a matter of law and fact, the complaint fails to allege that the Laundries were the legal cause of the plaintiff's grief, and the complaint should be dismissed. The pleader is bound by his own allegations in the complaint. In addition to the lack of support for the causation element, the complaint does not allege, let alone factually support, the emotional distress was severe. I probably would not have even made this argument. If I'm being honest, if I'm filing this motion to dismiss, I think I have plenty. I think I've pleaded all I need to at this point. I would leave this argument out, but they decided to put it in. Let me know what you think about it. Do you agree or disagree that this emotional distress was in fact severe? The complaint spends most of its paragraphs discussing the Laundries provides nothing beyond the conclusory allegation of mental suffering and anguish by the plaintiffs. The term severe does not appear as a description of the plaintiff's alleged injury. Where the elements of a cause of action are not pled, they may not be inferred from the context of the allegations. But again, this is an easy fix with an amended complaint. And this is why you should put the elements of the cause of action in the complaint and in the count, because if they would have put it in the count, then what you usually say is, for a negligence claim, they breached this duty. They had this duty. They breached this duty. That breach of duty caused this, and here are the damages. So you make sure you hit all the elements as you're explaining it in the count. The same thing would have been here. They would have said the distress had to be severe, and it was severe. And that's basically all you have to do to overcome this. And I think most of us would agree that their distress was absolutely severe. So this is not a very strong point. When you do have strong points in a motion like this, I stick to the strong points and I leave out the weak ones. While the complaint alleges the plaintiffs were extremely distraught and desperately searching for information concerning their daughter, the complaint does not specifically discuss how plaintiff's mental suffering meets the severity element, nor does it describe their distress as severe. Again, I think this is kind of a weak argument. The fact remains, however, that significant feelings of fright, shame, worry, and humiliation, and others besides occasioned by the acts of the others are, even if regrettable, an unavoidable part of living in society. Thus, courts have tackled the issue, have recognized that a high standard of determining what kind of emotional distress is remediable in a claim for intentional infliction is necessary to prevent the tort of becoming a venue for litigation over every emotional injury. I do agree with them there. It does need to rise to that level. But in my opinion, it is severe. Whether or not it fits this cause of action, I think is still left to be seen, but I do think it was severe. In sum, the plaintiffs have failed to satisfy the elements of causation and severity. Plaintiffs were understandably fearful about what happened to their daughter, and they would have been upset about their daughter regardless of anything the Laundries could have said. I agree with that. But the fear or sadness was not caused by the Laundries. It was an unfortunate, unavoidable part of the entire circumstance surrounding Brian Laundrie and Gabby Petito. Conclusion. The plaintiffs have not and cannot set forth factual assertions that can be supported by evidence which gives rise to a legal liability. As such, this action for intentional infliction of emotional distress against the parents for Brian Laundrie, however inartfully drafted, is not legally sustainable, and the complaint should be dismissed with prejudice and without leave to amend for all the reasons set forth above. And again, Matt Luca is the lawyer that filed it. It's a good complaint. A good motion. I think he's going to win. I think it's going to get dismissed. Let me know what you think in the comments. Do you think it's going to get dismissed or not dismissed after hearing this entire complaint? But now, do you think that they're going to have the right to amend or not? And the way we can do that is put amend in the comments or not amend in the comments, because I think they are going to have a right to amend. I think they should have a right to amend. I think they should have a right to add more facts. The defense attorneys laid everything out on the table at this point. Here are all the problems with your complaint. The judge could say, have at it. You better fix all these problems with the complaint, because you know another motion to dismiss is coming, and it's not uncommon to have a complaint, a motion to dismiss granted, an amended complaint, another motion to dismiss before we ever get to actual litigation. And this may be something that's not handled until summary judgment way down the line. If it was a negligence claim, it's pretty easy to get past motions to dismiss, and then maybe you may lose on summary judgment, but even then, usually you win on summary judgment. But because of this specific allegation, and because we don't want the courts flooded with emotional distress complaints, whether it's negligent or intentional infliction of that emotional distress, courts are more likely to dismiss with prejudice eventually this cause of action. But at this point, since we don't even know what their cause of action is it intentional infliction of emotional distress, negligent infliction of emotional distress? And I think they picked intentional in this motion dismissed because it's easier to get that dismissed. It could even be tortious interference with a dead body. We need the plaintiffs to amend this complaint. We need it to be more specific. We need it to be specifically plaintiff to defendant, and we need specific causes of action and counts and elements and facts pled with those counts and elements so we can see how legitimate these causes of action may be between the Petito's parents and the Laundrie parents. So that was as quickly as I could get through it. 30 minutes to get through 20 pages, I think is pretty decent. Let me know what you thought in the comments about this video. If you enjoyed it, hopefully you did. Hopefully you learned something. Like the video if you did on the way out. But for now, that's all we've got. Until next time.
Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.